We are very excited to be here today to host our second annual Family Law Now virtual summit. If we haven't met before, my name is Shannon and I'm the Community Engagement and Events Manager at Russell Alexander Collaborative Family Lawyers. I'm also joined here with my colleague Shanza, who's an articling student at our firm and will be co-hosting the event with me today and tomorrow. First of all, we want to give a warm welcome to all of our viewers joining us for this event. We have a fantastic lineup of speakers with some very interesting discussions to look forward to on a variety of family law topics. We would like to thank all of our esteemed presenters who are participating by sharing their knowledge and experiences. So we have Adam Prewer here from Epstein Cole to start us off with a case law update. And we ask that you keep in mind that all of the content provided in the presentation is intended to provide general information on separation and divorce and family law matters and should not be construed as legal advice. Before I get into our introductions of our presenters, I would like to just start by acknowledging the Indigenous peoples of all the lands that we are attending from today. While we meet virtually for this event, I would like to take a moment to acknowledge the importance of the lands which we all call home. We acknowledge the ancestral and unceded territory of all the Inuit, Métis, and First Nations people that call this land home. I would like to personally acknowledge the land that I am presenting from today, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee, and the Wendat people, and is now home to many diverse nations, Inuit and Métis people. So now I am going to get into some introductions. So first, I'm going to start off by introducing our chair of the event, Russell Alexander, as well as our first presenter today, Adam. So first, I will start with Russell. He is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. With 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them cope with the difficulties of separation and divorce, the division of assets such as homes and pensions, and the calculations and enforcement of child and spousal support. He uses his experience to create unique solutions for each client to enable them and their families to move forward and support them through the transition of divorce and separation. Russell has written 4 books on separation and divorce and is a fully trained collaborative practice lawyer, and he speaks at many conferences on collaborative practice, marketing, technology, and the law. Next, we have Adam Prewer, and Adam was called to the bar in 2013 after completing his clerkship for the Senior Family Justice, the Associate Chief Justice, and the judges of the Ontario Superior Court of Justice. Adam has co-authored numerous papers with Aaron Franks, Sheila Gibb, and Ilana Zilberman Dembo, along with some independent writings of his own. He has presented for the Halton Country Law Association, ILCO, the OBA, the LSO, and some other places with acronyms. Adam has significant courtroom experience appearing at the Ontario Court of Justice, on Ontario Superior Court, and the Court of Appeal for Ontario. He is also certified in collaborative family law, and he has particular interests in jurisdictional issues. And lastly, Adam is a co-author of Unpacking Family Law for Practitioners with Justice Melanie Kraft. Now I will pass it over.
Other places with acronyms, are you just too lazy to read it off, or did Adam write it down?
No, I always sneak a joke into my bio just to really mess with the person.
I think Shannon's running out of breath here. She said, "Oh yeah, he's from places unknown."
Already said enough. Yeah. Well, on that note, I'm going to pass it over to you, Russ.
I'm going to hand it right over to Adam because he's got a lot of great stuff, and I want to hear what he has to say. And first of all, thank you everybody for attending today. And let's hear what Adam has for us. Thank you.
Thanks, Shannon. Thanks, Russell. Thanks, Shanza. So what I'm going to be talking about today is the case law update. For those that don't know me, I'm at Epstein Cole. Much of the content in my paper, if you don't have it yet, you'll get it, comes from This Week in Family Law, which is done by Aaron Franks and Michael Zalov at my office. Sometimes I get to write some of the summaries, or at least a little portion of it, and I get to come and talk about case law. It's a wonderful newsletter to read. It's quick, it's easy, it's written in a style that everyone can understand, and it lets you keep abreast of developments in the case law. And I'm going to be talking about a selection of cases over the past year that I think are really interesting, really important. And I'm going to try and break down each one as to what you need it for, particularly if you are a practitioner, where you can work it into a factum. If you've got any questions, please send them over in the Q&A. I'll try and get to them sort of halfway through and maybe at the end. And if I go too fast, I apologize. There's just a lot of great cases to talk about. So the first two cases I'm going to talk about are actually sort of combined together on one issue. And they are Depoche and Depoche, which is 2022 ONSC 2099, and Altman, which is 2022 ONSC 4479. Depoche was a decision by Justice Shore, and Altman was a decision by Justice Falletta. Both of these decisions deal with how we as practitioners can use Rule 1.8 of the family law rules when someone's failing to obey an order. So Rule 1.8 permits a court to make a number of different orders when someone has failed to follow a court order. And specifically what we're talking about here is whether you can do a daily fine against someone who is not complying with a disclosure order. These are sometimes called Mantella orders after a case called Mantella and Mantella, which was back in 2008. In Mantella, the court ordered that the husband needed to provide certain documentary disclosure and charged him $2,500 a day for every day he did not comply. As you can imagine, there had been a lot of breaches of disclosure orders coming up to this, but that was what was done. Eventually, the wife brought a motion because the husband complied after 74 days, and she wanted an order confirming the fact that he now owed her $185,000. Justice Van Mel took a look, said, yep, that's right. And the husband then appealed the decision. Now, this is where things get very interesting because the husband appealed it to the Court of Appeal. And the Court of Appeal said, this is a really interesting issue. This is an important, novel issue. However, this is on an interim motion. The appeal doesn't belong to us. It should have gone to the Div Court. And it never did. So we have this Court of Appeal decision that says, maybe you can do this, maybe you can't. It's novel, it's interesting. And we've had two lines of case law flowing from Mantella. And Depoche is sort of now the leading case of one line of case law. And that is the line of case law that says these Mantella orders are available under Rule 1.8. Justice Shore looks at a series of cases, looks at a situation where the husband, again, very serious non-disclosure. And she makes a specific finding in this case that the husband was engaged in what she called a scorched earth approach. So this is someone who is intentionally trying to starve out the other side to make them spend legal fees, to be using his superior resources to try and gain an advantage. Justice Shore orders the same amount as they did in Mantella, $2,500 a day, for every day the husband's disclosure remained outstanding. So if you want a Mantella order, Depoche is the case you're citing. Now, what happens if you don't want a Mantella order? You want to resist this? Well, you want to look at Altman and Altman. This is a decision by Justice Falletta. Justice Falletta goes through and he looks at everything, and he has another serial non-disclosure. In this case, the husband had a very significant net worth. The net family property, his net family property on his own evidence was more than $30 million. So very high net worth guy who is ignoring all sorts of orders. He is not following the rules, and he is just sort of flaunting the court in many ways. The wife asks for a Mantella order. And I want to be clear, Justice Falletta does not like this guy's behavior. And he is very clear that it's unacceptable. And he says that it's unacceptable. And essentially, he gives the husband one last chance to come into compliance. And if not, he's going to strike his pleadings. However, Justice Falletta sets out that a mantella order is essentially a fine by another word, and fines are remedies for contempt of court. Rule 1.8 doesn't have the same requirements as contempt. You don't have the same notice provisions as contempt. You don't have the same evidentiary requirements as contempt. Under Rule 8, you just need to prove on a balance of probabilities that the court order has not been followed, and then the court has access to those remedies. Justice Fayetta was concerned essentially that he was eroding the protections around contempt by ordering a mantella order, so he declined to do it. And this is where things get also a little strange and frankly a little disappointing, because the wife appeals the decision to the div court. So here we have a chance for an appellate body to finally weigh in as to whether a mantella order is something the court can do under Rule 1.8. And if you recall, in 2009, when the Ontario Court of Appeal said they didn't have jurisdiction, they said this is a novel and important issue. So it seemed like it should have been a slam dunk for the div court to give leave to have the appeal heard. But unfortunately, the div court declined to take it up. They declined to give leave to appeal. And that doesn't mean they are saying the decision is good or bad. They're just saying they're declining to give leave for the appeal. So that means we still don't know. We have two very divergent set of cases. There's about half a dozen in each camp. And we don't know whether or not one is correct or the other. But it's a very important point. It's a very interesting tool for the toolkit, especially in a situation where you have serial non-disclosures. The next case is called Peters and Attichui. It is a 2002 case, so 2022 Alberta Court of Appeal, so ABCA 347. You're probably wondering, why is Adam talking to me about an Alberta Court of Appeal case? The answer is because Alberta has finally joined the rest of the country in terms of how we impute income for underemployment. Prior to this case, Alberta had a requirement that you had to prove a specific intention to undermine or avoid support obligations to impute income to someone under Section 19(1)A of the Child Support Guidelines. It's the only province that had this requirement. And as you can imagine, that was very onerous. It put far too much pressure on payees to establish an evidentiary basis of intention for the payor. So they have now joined sort of the rest of us. But what does this mean as a practitioner in Ontario? Well, because the Alberta Court of Appeal is making such a big change to their law, they do a tour de force summary of all of the case law on this issue across the country. So if you are looking for a great place to find good examples of imputing income, good statements of the law, great summaries of those leading cases, look to Peters and Attichui. And it has some wonderful stuff in there, citing many Ontario cases actually as its authority for them. But they have a wonderful non-exhaustive list of principles that could be pulled right out of the Court of Appeals decision and slotted right into a factum. And it has all of the things that you could possibly want about imputing income, including when a payor is required to look for work that is not as high of a level as they used to be. So if someone was a CEO, they lost their job, they're trying to find an equivalent job, but they just can't find it. It's got information as to when that stops being reasonable and they need to start looking for something sort of lower down the corporate ladder. It deals with situations when people were adopting certain roles prior to separation. It also deals with times when someone switches a job because they don't find their job very fulfilling. There's a great line that says that the personal fulfillment of a payor is a factor that can be considered, but it's not a determinative factor. We have, and there are just great sites. So it's a wonderful case for everything you need to know about imputing income in a case of underemployment. The next case, Bradford Estate in Kingdon, 2022 ONSC 6204. This is a very specific problem that we need to look out for. It actually came up in my practice about a year and a half ago. So what to do when a family law litigant is very ill? So under the Family Law Act, if you are very sick, you need to consider starting an equalization claim right away, because an estate cannot make a claim for equalization. What this means is that if you have a litigant, they are very ill, you need to consider starting an application as a defensive measure. So in this case, the husband and wife were separated. They both retained counsel, and they started trying to resolve their family law issues. However, during the negotiations and before either party starts litigation, the husband became very seriously ill. He was hospitalized twice in April of 2020, and he died on May 7th, 2020. The husband and wife, they owned the matrimonial home as joint tenants. So by right of survivorship, that moved solely to the wife's name. She also probably started receiving monthly payments from the husband's pension as her survivor pension. But what wasn't done was there wasn't an equalization of the property. And had that happened, the husband was actually owed a payment. The husband's estate in October of 2020 started an application against the wife for the EP, and the wife, quite correctly, brought a motion for summary judgment. She argued that it should be summarily dismissed because under Section 5 and 7 of the Family Law Act, the spouse of a deceased person can start a claim, but an estate cannot. A claim for equalization is a personal claim that has to be started when the person is alive. An estate can continue an existing application, but it can't start an application of its own. And the court says exactly that. Is this a fair rule? Maybe not. I'm sure there are very different views of this depending on where you are or what your practice is under. But it's very clear, whether it's fair or not, it's really clear. So I had a situation wherein this occurred. The other side, we had been negotiating a long time. The other side passed away. The estate tried to do an equalization claim, and my response was, you can't. That's shut down. So this has long existed. Bradford is a great case that says it really explicitly and sets out all of the reasons why, all of the various statutory principles as to why this is the case. And it just is what it is. Unfortunately, there is some very serious risk for counsel. If we have clients that become ill, we need to tell them about this. It could potentially be a negligence issue if we don't. There is also, if you are in a Bradford situation, there may be unjust enrichment claims to make, particularly around sort of matrimonial homes that are held jointly or tenants in common. But those are all sort of like secondary tools in the toolbox. If you have a client that's ill, you really need to think about starting an application to preserve those rights for the estate. The big case of the past year was, of course, FNN 2022 SCC 51. I'm not going to spend a lot of time talking about it because you guys are going to have Fareen this afternoon, and Fareen is by far the expert about this case. This case deals with Section 40 of the Children's Law Reform Act, which is what applies when we are dealing with child abductions and non-Hague countries. So in this case, the parties were married in Pakistan in 2012, but they lived in Dubai for their entire marriage. They had 2 children together. The mother and the children were Canadian citizens, but the father was not. With the father's consent, the mother left Dubai in June 2020. She said she was coming to visit her family in Ontario. And although she had purchased a return plane ticket, she stayed in Ontario and told the husband that she would not be returning to Dubai. The husband starts a court proceeding in both Dubai and Ontario and asks for an order that the children be returned under Section 40 of the CLRA. Where this becomes very important is that the mother argued under Section 23 that removing the children from Ontario would be against. Section 23 allows a court to decline to send the children back to another jurisdiction if it determines that there is a risk that the child would suffer serious harm. And the mother argued that returning the children to Dubai would cause them to suffer serious harm because the children were very young. They were 8 and 6. They were younger than that. They were born 2016, 2019. So when they came to Ontario, they were 4 and 2, respectively. They were very young. She was their primary caregiver. She had no legal status in Dubai. She said that her ability to remain in Dubai was tenuous. It was dependent essentially on the husband. 3, she would not get a fair hearing there because the courts did not decide parenting cases based on a, quote, best interest test. And if the children were returned to Dubai, she would not return with them. And that's the really important part of this case. She led evidence saying that if the court ordered them to return, she would not go back to Dubai. So she was essentially saying, if you order them to return, then their primary caregiver will not go with them. You'll be separating them from their primary caregiver. The trial took place in November 2020 and finished on November 26th. In many ways, at least at the trial level, this is an example of how abduction cases are supposed to go. The court really moved a lot of resources. Counsel moved a lot of resources to make this happen quickly. Justice Conlon, who was the trial judge, he released his decision after 2 weeks because he recognized the importance of this to get it done quickly. He rejected the mother's arguments and found that although the young children could face emotional and psychological impacts, and sort of that is a possibility in general, it was unknown whether that would happen for these specific kids. What does that mean for a practice point? You can't rely on a general statement. You need to bring evidence in. So you've got the general statement, you need to bring it into the specific children. He found that it would be in the children's best interest to return to Dubai with or without the mother, so a court could adjudicate on the matters of custody, access, and guardianship. Both parties brought expert evidence as to what the law in Dubai was. Counsel for the father did a really good cross-examination, and the trial judge was content that it would be determined essentially on the best interests, even though those specific words weren't part of the law. Then it goes to the Court of Appeal. This is where that timing thing kind of breaks down. The Court of Appeal clearly has trouble with this. The appeal is argued in January 2021, and then the Court of Appeal takes 8 months to release its decision. It's a 2-1 decision, the majority supporting the trial judge's decision, with a very, very well-written and passionate dissent by Justice Lowers. Then we go up to the Supreme Court of Canada. This is a very rare situation in Canadian case law because this is a 5-4 split. And it's actually quite rare to have 5-4 splits for the Supreme Court of Canada. Normally, we are a much more collaborative bench at the very highest, I suppose. The majority ultimately supports the trial judge's decision, finding that they would not overturn the determination that the children would not suffer serious harm. That's a determination that is entitled significant deference, and the mother had failed to establish an error in law or material error in the appreciation of the facts. What is particularly important in the majority's decision is it sets out a very clear roadmap as to how to apply Section 40. It does sort of incorporates some of the case law about the Hague Convention, because it's important to note this isn't the Hague Convention. And what's very interesting is it sets out as a general principle that a parent should not be allowed to create a situation that is potentially harmful to the child and then rely upon it to establish a risk of harm to the child. So what that means is the court is stating it is a general principle that we don't want to discourage abduction, that abduction and wrongful retention is presumptively in a child, contrary to a child's best interest. So you can't take a child, bring them to Ontario, and then say, I'm not going back in most cases. However, the court did acknowledge that there are going to be situations where a parent is unable to return to the previous jurisdiction, and their refusal to return may be completely reasonable. The onus to prove that a child would suffer serious harm rests on they use the term abducting parent, which perhaps is a little problematic, but it's the abducting or retaining parent, essentially the person asserting serious harm. They have the onus to prove it. It's a very factual determination. And one has to remember that when you are dealing with Section 40 or the Hague Convention, it is not a question of what is in the children's best interest in terms of a schedule or who they should primarily reside with, or even where they should primarily reside. The question is just what court or tribunal gets to make that decision, right? So that's what the court is focused on. Here, they said Dubai was the court to make that decision. The husband and wife both had excellent lawyers who marshaled fantastic arguments. There is a dissent written by Justice Jamal, which is a fantastic dissent. Just wonderful legal writing, both for the majority and the dissent. The dissent essentially said that the trial judge made palpable and overriding errors in the facts. They reweighed the evidence and concluded that the mother had established that the children would suffer serious harm. Essentially, the dissent did not believe that she would be treated fairly in Dubai. That was the core of the dissent's issue. They didn't think that her rights would be protected in the Dubai system. So that is a very important case that I'm sure Farine is going to talk to you more about. So the next case is, it's right. Part of it was 2021, part of it was 2022. I can never pronounce it. It's Wiazemska and Safin, 2022 ONSC 7311. So in Ontario, we have what is sometimes called the Rothgeiser problem. And the long and short of it is this: because of a whole lot of constitutional machinations, if you are married and your spouse gets a divorce, a valid divorce outside of Canada, you are unable to claim spousal support in Ontario. This is because of the specific wordings of the Constitution Act and the Family Law Act in terms of what it recognizes as a spouse for spousal support purposes. So what do you do in a situation where someone has intentionally run out to get a divorce from another jurisdiction to defeat their spouse's spousal support claim in Ontario? Because that's exactly what happens in this case. The parties were originally married and lived for a short period of time during their marriage in Russia. The wife was a lawyer in Russia, and the husband was an engineer. They came to Ontario. The wife essentially was unable to work outside of the home, and the husband was an engineer, and he was actually quite a successful one. So they are together and they separate. About 1.5 years after moving to Canada, they separate. The husband moves out of the matrimonial home and he applies for a divorce in Russia. And the wife filed an objection with the courts in Russia, as was her right, and she made a bunch of arguments, and ultimately the Russian court issued a divorce. So the wife made 2 arguments. The first one was not a very good one. First, she argued that she didn't receive proper notice of the Russian divorce. Difficult argument to make out when you have actually participated in the Russian divorce proceedings. The second argument, which was a better and more interesting argument, was that the court should not recognize the Russian divorce as being contrary to public policy. This is a very interesting case. I would highly recommend everyone give it a very careful read if you have a situation where you have sort of multi-jurisdiction families where someone could go out and get a valid divorce elsewhere. In this case, the judge chooses to not recognize the Russian divorce, and she does that because there's evidence led that the husband had been on a website which was for Russian expats that explained the best way to divorce your wife in Canada, and explained explicitly to rush to get a Russian divorce, pun not intended, in order to defeat the spousal support claim. So he knew what he was doing. He did that intentionally. And Justice Steele, in this case, declined to recognize the Russian divorce because it was contrary to the public policy in Ontario that values spousal support. So because it was done explicitly to defeat the spousal support claim, it was not recognized. That's actually pretty problematic. We are supposed to decline recognizing foreign orders when the law itself is contrary to public policy, not the facts or the actions of the parties. However, Justice Steele was so concerned that the wife's claim could be defeated that this is what she used. And this has been done in other cases. There's another case where the court declined to recognize an Iranian divorce because it would defeat spousal support claims. And there is a case where the court declined to recognize a divorce from Texas because it would also defeat a spousal support claim. So a very important case if you are in a situation where someone has run off to get a foreign divorce.
Adam, we're going to give you a chance to grab a sip of water and run a real quick poll. While you're doing that, do you think the Supreme Court got the Dubai case correct?
I think that it's so difficult to answer that question because based on the record before the trial judge, yes. This is where I become a bit of an analyst. Like, I've done a lot of cases in the United Arab Emirates, and I have had experts come in. And I agree with the dissent in the Supreme Court. I don't think the wife will get a fair shake in the United Arab Emirates. It is.
But I guess they're relying on the policy that you can't put yourself in a situation where you effectively do an end run around the rules. Was that the main point?
It was that, and the husband's expert during the trial. Like, that was the trial judge accepted his evidence that the best interest would be applied, that essentially the wife would get a fair shake. And the husband's lawyer did a masterful cross-examination of the wife's expert, right?
Yeah.
So on the record before the trial judge, it was the right decision.
But in your experience, it may not have been the right decision dealing with some cases out of there.
It's difficult for me, having done so many files in the United Arab Emirates, to say that she will certainly get a fair shake and her rights will be protected. Right. It's difficult for me to accept that.
For our audience, we run polls throughout the day just to get a sense as to what you're thinking and help us to get to know you a little bit better. So this poll is just tell us a little bit about yourself, pick one and give us a sense as to who the audience is. Shannon, can we see the results? All right, family lawyer, 74%. Well, you're in the right place. Adam's gonna get you everything you need to know. Professional, 5%. Law clerks, lawyer in another practice area, 9%. Law students, we love students showing up, going through a personal matter and helping a loved one. So thank you. Let's get back to Adam and learn some more. Back to you, Adam.
Thank you. All right. So the next case is Byers and Byers, 2023 ONSC 297. This is a case by Justice Tellier. This case actually came about of a 14B motion where the husband was seeking a voice of the child report. The wife was very concerned about the voice of the child report. She did not want to consent to it. She acknowledged that the person the husband had picked was an eminently reasonable and qualified person, but she was concerned because her view was that the children were aligned with the father, that he was influencing them. And as a result, a voice of the child report wouldn't be a fair descriptor of how they really felt. Voice of the child reports, as sort of the practitioners may or may not know, it's a very hot topic among voice of the child reporters as to whether or not those reports should contain any sort of recognition or analysis of the independence of the children's views. It seems that the general sort of majority, but not a very large majority, perhaps just really the plurality, are of the view that a voice of the child report is there to report what the child has said, but not necessarily to explore whether or not that that statement was independent or being influenced. So what does Justice Tellier do with a 14B motion? She writes a treatise on voice of the child reports. She writes a great summary of all of the law around it, of the principles as to when it will be applied. She even takes time to make a statement as to when a court will order a Section 30 assessment. She is one of the clearest judges to say explicitly that Glick and Kale, Justice Kitely's 2013 decision, is the test for Section 30. And she doesn't want to hear about clinical issues anymore as being the test. An interesting point, a great case for Section 30s. What is also very interesting is this is a case wherein the child was very young. The children were 8 and 6, and for the 6-year-old, there was some concern as to whether or not a 6-year-old could participate in a voice of the child report. In this case, it was allowed because the voice of the child reporter explicitly stated that they felt that they could do a voice of the child report for a 6-year-old. But Justice Tellier did telegraph to the parties that she had some concerns about a report concerning a 6-year-old. Specifically, she acknowledged that every child is unique, and some children may be more mature than others, but there was some recognition that that might be difficult. In this case, the judge did order the voice of the child report to take place. This was a very specific issue. It was whether or not the husband was going to get a relatively modest bump up in parenting time. And it was his evidence that the children wanted it. They really wanted it to happen. And a wonderful case for voice of the child reports, a wonderful case for Section 30 reports. And Justice Tellier is one of those judges that when they write a decision, they give you all of their math. So they've got all of the cases they're citing, they've got the history, and it was from a 14B. So I'm sure the parties were quite surprised to receive such a lengthy and thorough decision from something just in writing. The next case, which was one that everybody talked about at the beginning of this year, and I won't belabor the point a lot, it's JN and CG 2023 ONCA 77. Hopefully, knock on wood, the very last case we need to hear about the COVID-19 vaccine. In this case, the Court of Appeal dealt with a trial decision, in fact, actually a motion decision, wherein the motions judge had made a series of pretty significant errors. Essentially, the parties had disagreed as to whether or not their children should receive the vaccine. The mother brought a very large amount of information from the internet about all of the dangers of vaccines and the essentially experts that she claimed, but neither of them had actually called expert witnesses. It was all online sources. The husband had Health Canada and the Canadian Pediatrics groups, and the mother had, call it alternative resources. The Court of Appeal determined that the motion judge had made a series of errors. The first being that a court can't just accept evidence from, quote, experts that are online. Courts have a role to filter out prejudicial evidence, even when it's just a judge and no jury. So even in family law, courts have to focus on expert evidence actually coming from experts. This case has the test for the admission of online materials in it, and because you can adduce online materials, and there's actually a specific test which the Court of Appeal sets out here. They need, essentially, you need what are called indicia of reliability. And those are whether the information comes from an official website from a well-known organization, whether the information is capable of being verified, which is really where all of the mother's evidence fell apart, and C, whether the source is disclosed so that the objectivity of the person or organization posting the material can be assessed. So if you want to rely on a website, that's what you need to establish. Be very careful about relying on websites, because an online test, as the Court of Appeal states, is not a substitute for the admissibility of expert evidence. However, you can rely on evidence that is put forward by the government, and specifically public policy statements or public informations that are put out by the government. This is actually set out in Section 25 of the Ontario Evidence Act. Not a lot of people know that, but it's right there. And it states that copies of statutes, official gazettes, ordinances, regulations, proclamations, journals, orders, appointments to office, notices thereof, and other public documents. And interestingly, this has been in our law so long that it is public documents purporting to be published by or under the authority of the Parliament of the United Kingdom or of the Imperial Government, or by or under the authority of the government of any legislative body under any dominion, commonwealth, state, province, colony, territory, or possession within the Queen's dominions. So this is a very old part of the law, but this is the exception to allow people to adduce public documents as evidence. You don't have to call the Minister of Health to rely on something from the Ministry of Health. There is also a specific hearsay rule, or specifically an exception to the hearsay rule for public documents. And this was developed in the common law simply to save time, because it would have been unfair to have to call all of these ministers in. They wouldn't want to have done it. So you can rely on those public documents. The Court of Appeal also deals with Voice of the Children's reports and when you can attack them. In this case, there was a Voice of the Children's report where the social worker who did it found the kids' voices went to be very clear and very honest, because the kids were very clear that they did not want the vaccine. However, by relying on it, the motions judge made a mistake, because it was very clearly being influenced. And this was in the report when the kids explained that their mother had told them that the science was not clear on the vaccine. The 12-year-old child in this case had said that the mother had advised them that every time the vaccine had been tested on an animal, the animal had died. So very clearly a influenced voice. It does lead to a very difficult situation, however, which I will address. And finally, the Ontario Court of Appeal also stated that it summarized the cases in Ontario that said, essentially, if you want to oppose a vaccine, the onus is on you to establish that the vaccine is not in the best interest of the specific children. They've got some sort of health issue that makes them different from the general public. And the Ontario Court of Appeal cited those cases. So that is now appellate authority for that reverse onus when it comes to vaccinations. It's a little unclear. They don't explicitly state it, but it's certainly a very good case for that. In this case, the Ontario Court of Appeal granted the father's sole decision-making authority over the issue whether to vaccinate the children. You really have to wonder what the father is supposed to do in this situation. You have kids that are very clearly against this, whether they're against it for their own reasons or because their mother influenced them. You have a real problem. You have a real problem. The father, is he going to like drag them kicking and screaming? Are the doctors or the nurses or the volunteers going to feel okay injecting a child that is screaming and yelling at the top of their lungs? I don't know. I think that this is correct legally, but my heart goes out to the father in the situation he's going to be in. Another case, DS.
Adam, could I just ask you a quick question?
Sure.
For some, doesn't the child's consent required?
So the child's consent is required, and the older kids in this case that was applicable to it. It's also a major issue that, again, is sort of where a court order can say whatever a court order says. But yeah, like the doctor, the nurse, whomever, are they going to be willing to give a vaccine when a child is saying, no, I don't want it? And I question whether many of them would be.
And that's a whole nother test, right? In terms of
That's
determining
a whole nother ball of
consent.
wax.
Okay.
And it's also one of those.
I'm just saying that's another thing to keep in the back of your mind when you're thinking about these cases.
Yeah, it's also a practical matter too. Whether you've got a court order or not, it's going to be a rare doctor or nurse who says, I'm not, if he or she says she doesn't want it, I'm not going to do it.
I don't think they can.
Yeah, exactly.
Okay. Sorry for interrupting.
No problem. So there's a really good question that I'm going to try and save some time for. But there's a great case out of Alberta, DSJ and PRD, 2023 ABKB 84. So this is a case about surreptitiously obtained text messages. Basically, I've often told clients that there is no smoking gun in family law, but this is a case where there was a smoking gun in family law. The husband has a truck. The wife, he and the wife are both on the loan for the truck. The husband stops paying the mortgage. He stops paying the payments on the truck. So the bank comes to repossess the truck, calls the wife because she's on the loan document, says, hey, we're going to repossess this truck. If there's anything in it, come get your stuff. So she goes, the bailiff is there. He opens up the truck because, in fact, she has a key. So she goes in. What's in the truck? It's the husband's cell phone. So she takes the cell phone. She uses, it's a little unclear how she gets into it, but she gets into it one way or the other. She uses something called decipher tools to download the father's text messages. And lo and behold, the father has text messages between himself and a friend saying that he is intentionally not going to pay anything and let the bank take it in an effort to screw the wife. It is rare that people are this explicit, but he is. So she gets those PDFs. She wants to rely on them in trial. He also admits that he is intentionally not working so he can avoid paying support. He says all of this in a text message. And of course, she wants to rely on this text message. The husband argues that she can't because it violates his privacy rights. The court goes through an analysis similar to surreptitious audio and video recordings, where the court says that it's an odious practice. We don't want to encourage people spying. It's very bad. However, if the probative value is high enough, we will let this evidence in. Here, the court determined that the probative value was sky high and that the normal sort of concerns around privacy were lessened because the husband had essentially abandoned the cell phone. He knew that the truck was going to be repossessed. He knew that his cell phone was in the truck. And as a result, those concerns were slightly less. The court tries to say, again, it's an odious practice, don't do it. But in this case, the evidence was just too probative and too important to ignore. It's a very important case when you are dealing with situations where someone gets text messages. You also have to be very careful. There are criminal law implications for clients hacking into other people's communications devices, be they cell phone or computers. It was unclear here how she got in. Maybe the husband didn't lock it down as clearly as he should have, or what have you, but unclear. Really important case, though, when you're dealing with text messages that have been surreptitiously obtained. Mitchell and Mitchell, 2023 ONSC 2341. The husband hadn't done what he was supposed to do before a settlement conference, wasn't following disclosure orders, and Justice Kraft awards $18,000 in costs against him. A fantastic case if you want to seek costs for people that are messing you around on a settlement conference or a case conference. However, a bit of a suggestion in your confirmation, in your brief, set it out early and often for the judge that you are going to seek these costs. Counsel also brought a bill of costs with them. What's really interesting is Justice Kraft was willing to go further than the preparation for the conference itself, but even award some costs based on the efforts to obtain disclosure to date. So a very important case when you are dealing with this situation, and it does indicate that perhaps courts are more willing to award costs at conferences. Anderson and Anderson, 2023 SCC 13. This involved a kitchen table agreement in Saskatchewan. The parties wrote it themselves, worked it out. Essentially, both of them were going to go their separate ways, and they would split the joint assets. There would be no, what we would call, net family property payment in Ontario. The Saskatchewan Family Property Act has similar requirements for a domestic contract as we do in Ontario, and this didn't meet them. It was in writing, and it was actually witnessed by their friends. However, they didn't have legal advice and there was no disclosure. This went all the way to the Supreme Court of Canada as to what do you do with this? And what the Supreme Court of Canada said was that in a situation where there is an agreement that does not qualify as a domestic contract or an interspousal contract in this case, the court must first assess the agreement for its procedural integrity and whether it arose from a fair bargaining process. In this case, the court determined that the process between the parties was actually fair. They both knew what they were doing. They didn't exchange formal disclosure, but they both had a very clear idea of what would happen. They were both relatively sophisticated people. They were not in a situation of duress. They both could have gotten lawyers, but chose not to. And as a result, if the court is satisfied that these sort of kitchen table agreements are argued in as a result, or are developed as a result of a fair bargaining process, they're entitled to significant consideration. So the court can put weight on them. In this case, the trial judge had discounted the agreement altogether. The Saskatchewan Court of Appeal actually upheld the agreement and enforced its terms. And the Supreme Court of Canada said that the Court of Appeal was correct. So this is a very, very important case, given the similarity between our Family Law Act and the statute in Saskatchewan and the frequency of these sort of kitchen table agreements. What does this indicate on a wider thing? It indicates that the Supreme Court of Canada is really leaning towards enforcing agreements. If it's a fair agreement, they want to give people the power to contract. In this case, the husband, if there was no agreement, he would have been owed an equalization payment of $90,000. Because the agreement was enforced, he had to pay the wife $5,000. So a very important case, because that's a significant swing. And perhaps it didn't go the way we might think. There was a very sort of narrow point case called Wu and Diorio, 2023 ONSC 3352. I will admit this, I was actually involved in this case. What this case stands for is if you are questioning someone, you are allowed to bring an expert with you. And you don't need to have two experts. So if you have your financial expert, you are questioning another party about something technical, you can bring your expert with you, even if that expert is going to give evidence. It sets out how you can exclude an expert if they are going to be a problem. And this test was previously sort of a mess. No one had really considered it, but Justice Myers does a very good summation of the law and a very clear direction as to what we are to do. It also sets out the case as to when courts need to override precedent, which is a very interesting thing and a really important case potentially. Finally, Ahluwalia and Ahluwalia, 2023 ONCA 476. I'm not going to talk a lot about this because a lot of ink has been spilled about this. So this is the end of the tort of family violence. The trial judge had developed it. Ultimately, what was fatal to the tort was that the trial judge had found that existing torts were met. And in order to create a new tort, the requirement is that the tortious behavior cannot be covered by existing torts. So here, because the torts of battery and intentional infliction of emotional harm were met, there was no quote unquote need for the tort of family violence. Beyond that, the important parts of this appeal decision are undeniably, irrevocably, irresistibly, torts do have a place in family law. The Ontario Court of Appeal says that very clearly. Frame and Smith does not mean that no torts can come into family law, and specifically allows for intentional infliction of mental distress and battery as coming into Ontario family law.
Wow. Awesome job, Adam. When you were talking about Section 25 of the Canadian Evidence Act and the Imperial government, I had this Star Wars image that
Oh, yeah.
Darth Vader's missives were now.
Nope, just historical colonialism still hanging
Yeah.
around in the statutes.
We do have a question that came in. I want to thank everybody for sending in your comments. A reminder, the paper's in the link. I want to thank Mark and Megan for donating. Really appreciate it. The question that came in, would travel advisories qualify as evidence put forward by the government? A part of me want to rely on this to restrict travel.
Yes, they do. I've explicitly dealt with this, but you want to be really careful because travel advisories are rarely explicit saying, do not go there. They will rather just be a wider sort of like, be careful about this or that. But travel advisories are, and there's actually a number of cases where the court has relied specifically on travel advisories.
So is be careful enough to restrict access, or?
The courts have found that if it's at sort of a medium level, because you will be surprised at how many places are medium levels of travel advisories, sort of a moderate risk. I had a case where the other side attempted to rely on a travel advisory to prevent my client from going to England because it was moderate, because there was a perhaps slightly higher risk of terrorism in England. Right. So you really want to be looking at when it's that red, because they go on a color system. I think red is really where you want to be if you're going to rely on a travel advisory.
And I think there was an advisory not too long ago about LGBTQ traveling to certain US states.
Yeah, to Florida specifically. There were concerns about it.
So you want to be mindful of that. Okay, Shannon, I think we're approaching the end of Adam's time. Anything else you want to wrap up on before we let him go?
Yeah, I just want to thank Adam. That was really interesting to hear from you and really appreciate you being here today, and some great feedback from the audience already. So thank you again.
Well, I thank you for having me. Thanks for everyone for listening, and have a great rest of your day.
Really appreciate your contribution, Adam. It was excellent. Thank you.